Today we are covering key aspects of the Texas eviction process and tenant rights for the Texas real estate exam. The exam will test your knowledge on the landlord's duty to repair. This duty is not for cosmetic issues. It applies only when a condition materially affects the physical health or safety of an ordinary tenant. For example, a broken air conditioner in July or a major roof leak would qualify, but peeling paint would not. Before a tenant can seek remedies, they must be current on rent and provide written notice to the landlord, allowing a reasonable time to make the repair. If the landlord fails to act, one of the tenant's most powerful remedies is the right to repair and deduct. Under this provision, a tenant can pay for a qualifying repair and subtract the cost from their next rent payment. The exam loves to test the monetary limits here. The deduction cannot exceed the greater of 1 month's rent or $500. Now let's pivot to the eviction process itself. It formally begins when a landlord provides the tenant with a written 3-day notice to vacate. This notice is a prerequisite and must be delivered properly, such as in person or posted on the inside of the front door. If the tenant does not leave after the notice period, the landlord cannot simply change the locks. They must file a lawsuit known as a forcible entry and detainer suit in the local justice of the peace court. The exam expects you to know this specific legal term. A common exam trap involves landlord lockouts for non-payment of rent. While a landlord can change the locks if the lease allows it and proper notice is given, they must provide the tenant with a new key 24 hours a day, regardless of whether the tenant has paid the delinquent rent. This is a critical point. The lockout is a tool to get the tenant's attention, not to physically remove them. Another tested concept is retaliation. A landlord cannot evict, raise rent, or decrease services within 6 months of a tenant taking a protected action, such as requesting a necessary repair in good faith. This creates a legal presumption of retaliation that the landlord would have to overcome. To remember the eviction steps, use this phrase: notice, file, judge, writ. First comes the notice to vacate. Then you file the forcible detainer suit. You get a ruling from the judge. And if you win, a writ of possession is issued to have the tenant removed. For free practice questions, AI-powered explanations, and more exam prep tools, visit openexamprep.com. That's openexamprep, all one word, .com.